I am delighted to welcome one of our visiting fellows at IALS for this webinar, Dr. Lucas Cora. Lucas is an assistant professor at the Department of Evidence Law and Forensic Science at the Faculty of Law and Administration at the University of Gdansk in Poland. And as I say, he is one of our visiting research fellows at IALS this year. Lucas completed his PhD on detention in Polish criminal proceedings. And in his research, he focuses on the law of evidence, on coercive measures, and protection of human rights in the criminal process. And Lucas has authored approximately 50 research publications. And we are delighted to welcome Lucas here. Thank you for agreeing to give this seminar. Just in terms of how we will run this session today, Lucas will talk for approximately 45 minutes, and then we will open out to Q&A. For the Q&A, we will turn off the camera and bring everyone together to ask any questions that you might have. Lucas, thanks again for joining us today. I will pass over to you now.
Thank you, Colin, for this introduction. And I want to thank you very much for inviting me to share my research subject with you. And I'm extremely grateful, and I would like to thank IALS for the opportunity to conduct research here in the University of London as a visiting research fellow. And first of all, I would like to share with you my short PowerPoint presentation. So just let me share the screen with you. I hope it will work out. Okay, what do we have here? Great. Let's make it more visible. Okay, so as you can see, the subject of my presentation is verification of evidence between the efficiency of the procedure and the guarantees of the fair trial in criminal proceedings. And there are three major subjects, three major things I want to discuss. First of all, I would like to answer the question, what is verification of evidence? In my humble opinion, what it should be. What are the major problems of evaluation of evidence in Polish criminal procedure, which is between inquisitorial and an adversarial model of the process, and do we have common convention standards for evidentiary? Of course, foreign participants, I have just prepared some provisions of Polish Constitution and the Code of Criminal Procedure in Poland, which I will focus on. So just let me skip ad rem to the main thing, the main subject of today's presentation. So if we may start, because I have only 45 minutes, and the first thing, of course, would be to discuss what I mean by verification of evidence, which is my main subject of postdoctoral thesis, because in Poland, after PhD, just to let you know, we have something like habilitation, which is in Germany also, but you don't have habilitation in the UK and in the USA. You have only PhD, and then you can be a full professor even, but without any habilitation. Yes, here in Poland we have this condition. So, Adram, this paper will undertake an analysis of the verification of evidence in the criminal trial in terms of expediency, quality, validity, correctness, and of course a matter of proportionality. My aim is to determine which elements are subject to gradation from the point of view of procedural values, to access their influence on the assessment of criminal responsibility, and examine the possibility of adopting certain solution from common law jurisdiction in order to better assess evidence in Polish criminal trial. A part of the dogmatic legal analysis, the most serious threats to the fairness of evidentiary proceedings, for example, the abuse of the right of proof or the illegal acquisition of evidence, we'll be discussing a different situation in different procedural settings and at different stages of the trial. Finally, it's an attempt the attempt is made to identify reasonable and fair admissibility criteria. About those admissibility criteria and as an introduction, I just want to say that Professor Andrew Ashworth Duff and also Thomas Weigand emphasize that the principles of admissibility of evidence ensuring the accurate establishment of facts and are prerequisite for the correct application of substantive criminal law and for the proper functioning of the criminal justice system in society. However, the search for truth must be limited to take into account the important values among which human rights occupy, in my humble opinion, a central place. The search for a fair balance between the effective fight against crime and respect for individual rights is constantly the center of this heated legal debate. However, there are two other factors that strongly influence the rule of evidence, creating an environment in which the pursuit of the truth is becoming more complicated than ever before. The popularity of non-trial case resolution, the impact of, and of course the impact of technology and science, which are related and directed at the efficiency of criminal justice system, paradoxically make the research for truth easier and faster, but also more prone to different errors. Moreover, for example, new technologies enabling the collection of evidence have become a significant threat to the right to privacy. Finding solution to these challenges requires multi-stakeholder dialogue free from the panel populism that has dominated legal discourse recently, not only in Poland, of course. If courts can simply choose a guiding principle in the circumstances of each case, there is unlikely to be a consistent approach there is a danger that the question of admissibility will be left to the out of meritorical court resolutions. Evidence in criminal proceedings is verified on two fundamental levels. One concerns the sphere of procedural axiology, so conflict of goods. The other, conflict of norms. And the purpose of criminal proceedings, as you probably know, in a matter of evidence, is to determine whether the accused has committed one or more crimes, and if so, to impose a lawful penalty. This requires balancing individual social legal goods, rights and guarantees, with the interests of justice and law enforcement, and finding an optimal compromise. The requirements to base judgment on evidence, it's a matter of the fact-finding, and it's not only necessary to reconstruct the relevant facts, but it's also, but is the only reliable source of information. For example, the only source to enable courts to make a correct decision. A finding of guilt requires that the prosecution and defense present and challenges the evidence, that the court's factual findings can be as accurate, or should be, as accurate as it is, of course, possible. And statutory restrictions on the means of obtaining evidence and the procedural rules governing its admissibility and the ways in which it is to be assessed and managed are designed to uphold values relevant to social relations. The conflict of social legal goods is in a criminal trial. This boils down to a conflict between the need to accurately reconstruction the sequence of events and establish the context in which they took place, especially in Poland under the principle of material truth and the need to protect the rights and interests of individuals. Of course, criminal proceedings are those a compromise between a strict obligation to establish the truth and the purposefulness of preserving those universally accepted social legal goods to which the legislator have given particular priority. And evidentiary proceedings obviously play an important role in clarifying circumstances surrounding a criminal event. It involves a number of activities: searching, findings, disclosing, and securing sources of exhibits of material, documentary, or personal evidence, disclosing, so obtaining evidence from a known source, for example, interrogation, controlling, assessing the credibility and procedural usefulness of a given evidence. It is a duty of the trial authorities to take all legally permissible steps to establish the material truth from the moment of obtaining the evidence until its evaluation. It is essential that any decision of criminal responsibility can be taken on the, as I said, the basis of reliable evidence and establish an accurate as possible, of course, on the course of the events, the context in which they took place, so as to enable an appropriate criminal response. When we are analyzing the issue of verification of evidence, the indicated normative level should be treated as a basis and boundaries conditions for consideration. The kind of approach boils down rigorous competence of the trial authority for not only the need, but also a sort of obligation to look at the role and meaning of procedural cognition beyond a purely dogmatic reflection to an axiological, ontological, and also epistemological as well as conventional one. The thing is that by means of multifaceted verification of evidence, the subject of the final judicial decision, understood as a conventional process of judicial condition, led to the synthesis of the course and result in the form of statement of fact should be based on the examination of evidence, focus on the issues of usefulness, quality, standard, correctness, and, in my humble opinion, very significant issue, which is proportionality and applied methods in relation to the practical application of procedural guarantees. A model of fair trial from the point of view of the postulate to reduce any defects in evidentiary actions affecting the construction of evidentiary basis for judgment on the issue of criminal responsibility. So it is against the background that a well-founded view is formulated according to which is not possible to speak of a result which is in accordance with the criminal procedural law, in general contrary to the fundamental objectives of the criminal trial. Of course, the verification is defined as a checking the truthfulness, usefulness, or correctness of something. The colloquial, even dictionary definition is the one used in legal practice and evidentiary considerations. The essential elements of the law of evidence, which consist of the verification of activities related to obtaining, presenting, evaluating, and managing evidence or evidentiary actions, especially in the preparatory proceedings, the procedural proceedings, can be compared and analyzed at different levels and from different angles. Firstly, I have to admit they make it possible to access the evidentiary actions in terms of legality, admissibility, relevance, probative value, and correctness. Secondly, they make it possible to access conditions of a given evidential act. The verification of evidence consists, first of all, determining whether a given evidentiary act is justified by its purpose, premises, procedure, and effects. Basis, of course, basic issues dealt with legal institution. It is equally important to assess guarantee standards, in addition to need to justify the means of proof in terms of its legal admissibility, effectiveness, functional expediency, and axiological consideration might be, of course, taken into account. The correctness of this approach lies in the possibility of to determine whether the evidentiary act did not exceed the limit set by the law. No less important is the scope of axiological justification and the need to measure it not only with legality, admissibility, and correctness, but also with, as I said, quality, proportionality, and evidential value and power. Verification of an evidentiary act essentially consists of checking the manner in which it was carried out before verifying the veracity and probative value of the evidence thus obtained. In short, it consists of checking whether the finding is justified on the basis of the quality of evidence and the means by which it was obtained. In that meaning, the verification of means of evidence is carried out in a multifaceted and differentiated manner, taking into account the stage of proceedings based on the following criteria. Of course, the first is admissibility, relevance of obtaining specific evidence. Second of all, it's a regulatory legality and proportionality of their acquisition, the quality, standard, relevance, and reliability of any evidentiary findings. And the fourth one is the probative value and of course, value of certain evidence, like expert evidence, for instance, and its epistemological basis. So the verification of evidence involves several interrelated functions. All are subordinated to the purpose of the trial. Proper procedural fact-finding requires, as I said, the taking of evidence to be conducted on the assumption that the admissibility of evidence is undisputed, and the means and that the means by which it was obtained are unobjectable. The necessary predictions include the existence of positive prerequisites for the Evidentiary Act, the capacity of litigant concerned to take it, and the observance of modal conditions like place, form, and time. Against this background, a well-founded view is formulated according to which it is impossible to speak of a result in accordance with the criminal procedural law in general, contrary to the fundamental objectives of the criminal trial. At the theoretical level, the essence and value of verification of evidence lies in the fact that it is auxiliary to the objectives of the trial and to the functions of criminal procedural law related to the distinctions of the elements of purposefulness, formalism, and effectiveness of the evidence given. Therefore, the relevance and usefulness of using the verification of evidence, although it should first of all relate to verifying the truthness and thus the control of the conducted evidentiary action from the point of view of a factual finding made on the basis of evidence, should be considered insufficient and unsatisfactory. Therefore, it needs to be emphasized once again that the verification of evidence carried out at the different stages of evidence proceedings is in practice a complex, diverse, and multifaceted procedure. The verification of evidence requires a balancing of procedural guarantees with the trial authority duty to make findings of fact because of the special connection between the verification of evidence and the principle of substantive law and the free appraisal or assessment of evidence, which is not known in common law, actually. The trial authorities make assessments on the two fundamental levels. First, the relevance of evidence is established a priori, and possible contradictions are resolved. Second, the assessment of credibility, or a lack, therefore, of the evidence admitted by the court is made not a priori, but a posteriori, yes? And verification of evidence is a mechanism that equips a trial authorities, especially the judge, within the limits of discretion, with a broader analytical spectrum than mere knowledge, logic, and life experience, which are the basic of the free appraisal of evidence under Polish criminal procedure. And in the same or more the same is under the Strafprozessordnung in Germany. This warrant orientation of verification of evidence compels consideration of the subjective and objective considerations that justify a particular act of evidence and helps to ensure the findings are made on the basis of evidence that in turn provides a basis for making rational determination. Of course, a free evaluation of evidence, like testimonies, explanations, opinions, means that the trial authorities are free to rely on their internal conviction of and draw a rational conclusion from it. They are not bound with any schematism, if you know what I mean. But they are nevertheless obliged to take into account everything that enhances the probability value and evidential value of evidence. And this includes the correctness, proportionality, and legitimacy of a given act of evidence. And the court is free to accept some testimonies as credible and reject other as unreliable within the framework of procedural law, provided that it is logically examines them in the light of life experience and current knowledge. It includes a description of these examinations and the reasons why it reached such and not other conclusion into the ratio decidendi of the judgment. And furthermore, it examines the consequences of the search of evidence within the limits and on the basis of the evidence law in criminal procedure. So the verification of evidence against the background of the adversarial principle and its opposite model, the inquisitorial, it's extremely convergent. The European Court of Human Rights stresses, so the Strasbourg Court, as you all know, stresses the evidence should be obtained in the presence of the accused at the public hearing in an adversarial trial. The more adversarial the criminal trial, and consequently, the more the role of importance of the court in obtaining evidence is diminished in favor of evidence presented or challenged by the parties, as it is in let's say English and Welsh trial, or especially American criminal process. The greater the fear that the principle of material truth will be undetermined at the expense of a judicial truth. Since substantive truth is understood in the adversarial model as an optimization directive, the basis issue is to determine the circumstances relevant for the settlement in accordance with their actual course while ensuring compliance with the rules of evidence. It is therefore about such rules of evidence that maximize the possibility of making findings consistent with the reality within the prevailing factual and legal constraints. Verification of evidence is thus an optimizing activity which determine the way in which the court makes the findings of fact, which are axiologically and normatively justified by the guarantees stemming from the system of, well, in Poland, for instance, constitution values, and of course, standards of international protection of human rights in a criminal trial, limitations of prohibitions of evidence force the trial authorities to seek alternative actions and methods of evidence in the pursuit of truth. Of course, this issue is no different in the inquisitorial model. So in that case, verification of evidence should be also understood as assisting the parties in their search for evidence. This applies not only to the result of evidentiary acts, but also to their accuracy, proportionality, and the standard of proof. The example of this requirement to minimize the adverse effects and inadequacy of a given piece of evidence, modifying or rejecting a given piece of evidence in a consequence of balancing conflict social legal goods and then considering some as higher values and other truth-seeking versus coercive self-incrimination. Of course, the problem of determining the limits within which an item of evidence may be used despite its admissibility under the law of evidence lies in the material scope of the activity. The inadmissibility of Evidentiary Act is connected on one hand with clear prohibition of its use. For example, the prohibition of questioning a lawyer as to the fact obtained during the provision of legal assistance to a detained person, which is, of course, a matter of attorney legal privilege. And on the other hand, with the lack of the clear authorization to use it, the issue of the mutual relations between the abuse of rights and the inadmissibility of an act of evidence is revealed in procedural situation, which boil down to determining the limits of admissibility. Whether an evidentiary act is so abused as to be ruled inadmissible depends on whether there is an indication of its legal condition, it is prohibited by legal acts, statutes, yes. It constitutes ultra vires the relevant statute. The limit for its performance has expired. It was performed by a person not legally authorized to do so or not legally empowered to do so. For this reason, it seems reasonable to conclude that the misuse of an evidentiary act is tantamount of exceeding the permissible framework of its authorized performance. Because like 15 minutes we have more, let's skip to another thing. Let's focus on the problem of European Court of Human Rights. But first of all, as a result of the conflict evaluation, a conditional priority relationship is created in the form of a rule of conduct. The legislator creates general and abstract rules, not concrete rules, and the conditional relations of precedence becomes an individual and concrete rule when they are applied in practice. In criminal trial, the rule plays a decisive role for the proper determination of the case. Hence, when assessing and prioritizing rules and principles in a criminal trial, the process should be referred to the specific system. In this case, the law of evidence. The subject of analyzing should be those rules and principles which axiologically justify the normative solution adopted in the trial. And two basis groups of rules can be distinguished. The first are those that concern the protection of human rights and freedoms. Of particular importance are those that they are designed to protect the individual from unjustified restriction of their freedoms by law of enforcement agencies. They are codified to ensure the achievements of this goal. And the second group are constitutional orders obligation addressed to the participants in the institutional process. They concern the legal boundaries or framework scope of their activity, which is, of course, for instance, stressed under Article 7 of Polish Constitution. So priority should be given to that best guarantee of a fair criminal trial according to the standards of Convention of Human Rights and national constitutions. The main principles of the fair trial, as derived by the European Court of Human Rights and the Polish Constitutional Court, include the right to public trial by the properly constituted, competent and independent and also impartial court without any undue delay, the right to procedural fairness and consistency, the right to a trial verdict and adversarial equality of arms, the right to equality before the law, the right to presumption of innocence, and the right to legal assistance and representation, also the right to hear witness according to strictly defined rules, Constitution guarantees in the field of imprisonment, the right to appeal, the right to instance proceedings, the right to competition. And it should be stressed that the issue of admissibility of evidence under Article 6 of European Charter of Human Rights has not been explicitly regulated and depends on the authorizing legislation of the state parties to the convention with regard to the standard against torture, inhuman or degrading treatment. The European Tribunal stresses that the absoluteness of the prohibition under Article 3 of Convention applies to the personal and material evidence obtained in direct violation of that prohibition. Admitting evidence of conventions or statements obtained in clear violation of prohibition of torture, priority prejudices the fairness of the trial. With respect to evidence that constitutes forms of degrading or inhuman treatment or other violations like tortures, the court is required to consider the probative value and probative value of the evidence thus obtained and its potential contribution to the conviction. And second of all, the ability of the accused to challenge its use, and the public interest in proving criminal responsibility. Whether the admission of unlawful evidence obtained in violation of Article 3 violates the right to a fair trial depends on two fundamental issues assessed in a concrete case, namely the rule of the evidence so obtained and the ability the accused to challenge its use. Finally, the right not to incriminate oneself is understood as the right to be compelled to provide self-incriminating evidence. So it's the same under Polish criminal procedure, under the guarantee nemo se ipsum accusare tenetur. The Strasbourg court regards this right as a general prohibition on use incriminating evidence against the accused. As regards the Strasbourg court's case law on obtaining evidence through violation of the right to privacy, so Article 8, Paragraph 2 of Convention, such evidence is admissible only if it is necessary for the state security, public safety, the protection of public order, and the prevention of crime, or the protection of the right of freedoms of others. For such evidence to be admissible, it must have a legal basis, legitimate persons, and necessary, and of course, proportionate. Moving forward, because the time is passing, let's skip to the other problem. First of all, illegal obtained evidence. So attention should be drawn to the conflict between admissibility of evidence obtained illegally and constitutional values in criminal proceedings, which in concreto include the protection of the right to privacy, the citizens' trust in the state, the rule of law, and prohibition of torture, inhuman, degrading treatment, as well as the principle of the fair trial at the forefront. It is difficult to reconcile with the rule of law and procedural law that provides the admission of evidence obtained as a result of torture. The constitutional principle of the rule of law in criminal trial dictates that all acts of evidence must have a legal basis and be within the bounds of the law. This also applies to the compliance with the hierarchically higher norms of the Constitution, and a situation in which the legislature encourages or at least condones the obtaining of evidence in a criminal manner or in violation of procedural laws is difficult to accept at the level of elementary axiology. The verification mechanism serves to determine the admissibility of evidence obtained not only in violation of the law and/or the rules of criminal procedure, but also the principle of proportionality. When making factual findings relevant to the determination of the criminal liability of the accused, it is necessary to clarify whether the violation of the rules of procedure constitute a violation of procedural fairness, the principle of lawful conduct of the procedural authorities, and the principle of adequate penal response. This is done by considering the gravity of the violation and the significance of the illegally or improperly obtained evidence in England and Scotland. And on the other hand, in other countries, there are balancing tests related to the exclusion of evidence. Professor Anne Ryan from the Limerick University, she acknowledged that the most critical question in this balance is what types of violation of the law are serious enough to trigger the non-use of resulting evidence. The value judgment is sometimes made at the level of international law, as it is case of prohibition of torture, and sometimes that, of course, even common law. In England and Wales, we have Section 78 of the Police Crime and Evidence Act from 1984, the PACE, yes, which provides that in any proceedings the court may refuse to admit evidence on which the prosecution purposes to rely if it appears to the court that having regard to all circumstances, including the circumstances in which the evidence was obtained, the admission of the evidence would be so prejudicial to the fairness of the proceedings that the court should not admit it. And generally, if further balancing is required in the comparative perspective, courts may use more or must consider some or all of the following 7 criteria in deciding whether or not to admit this kind of evidence. First of all, the seriousness of constitutional violation, including whether it was reckless, negligent, willful. Second of all, the seriousness of the following, of the offense being considered by the court, the nature of the evidence to be excluded, is it its reliability, credibility, or trustworthiness. The nature of the evidence to be excluded, as I said, the public impact of the decision, whether it will cause concern in the community, in the society, whether the exemption is need to future violation by the police or other officer, and whether the decision will bring the court into disrepute, and whether the use of this kind of evidence would violate the defendant's right to the fair trial. The last and now predominant balancing factor, whether the use of evidence improperly obtained, of course, would violate the defendant's right to the fair trial, tends to be itself a factor-intensive test that encompasses many of the other 6 previous factors. And the discretion given to the judge by Section 78 of PACE has been described in the criminal literature as a broad and unstructured because of the multiplicity of factors that may consider, in the addition to the lawfulness of police action, the seriousness of the crime, the good faith of the officers, the type of evidence and its reliability, the existence of evidence to support the type of unlawfulness and the type of right infringed. And in applying the multi-factor balancing test, jurisprudence is based on, at minimum, the following factors: the seriousness of the objective and subjective deficiencies, such as clear lack or a legal basis for the specific action, a lack of a legal basis for the specific evidence gathering activity, deliberate, widespread, and or arbitrary, willful, widespread, and or arbitrary abuse of state power, or intentional, deliberate, widespread, and arbitrary circumvention of requirement of prior judicial approval, especially when the requirement is provided in the Constitution. Same in the German law. The German Federal Court of Justice, for example, has repeatedly examined whether the exclusion or non-use of evidence can be justified, in particular in the event of serious deliberate or objectively arbitrary violation of law, in which the protection afforded by the Constitution have been deliberately or systematically ignored. So just passing through the conclusion, in both systems, the objective and subjective seriousness of the failure to gather evidence is taken into account. And although only in Germany explicitly the seriousness of the crime being prosecuted, both criminal justice system also take into account, at least in part, a systematic effect, or the question whether there is a systematic, deliberate, and arbitrary disregard of procedural rules, and how the decision to exclude affects public confidence in the criminal justice, or like in the USA, the interest of protecting the integrity of the court and the public interest impact the admissibility decision. Okay, and right now let's keep to one of the last issues. I mean the proportionality, and after that conclusion. So just give me like 7 minutes. Okay, sorry for that. Proportionality is a particular importance when verifying evidence. Firstly, it is connected with the principle of adequacy, understood as an order to undertake such actions of the proof and to apply such methods of obtaining evidence which are adequate for the given case. Secondly, it relates to interference with the constitutional rights and freedoms by means of evidence. Statutory provisions restricting constitutional freedoms must meet the following conditions: necessity for the objective persuade, so the condition of necessity. Second of all, effectiveness, the condition of usefulness. And thirdly, the proportionality sensu stricto. For example, the effects of the application should be proportionate to the burdens imposed on the citizens. From the point of view of proportionality, the evidentiary measures in criminal procedure in the trial, the problem of balancing legally protected social and legal goods with constitutional freedom, and this is the major thing. The primary concern here is to ensure the adequate criminal response to prevent excessive interference with individual rights, human rights and freedoms. However, the requirement of necessity must always be borne in mind, whether applying means of proof that restrict human rights. It must be shown that the necessary objectives cannot be achieved by means of evidence that is less onerous for the individual. The principle of proportionality requires the three basic conditions: the means used to achieve the state aim is appropriate, interference as little as possible with human rights, and it appropriate to the harm caused by the act suspect in accused committing. So proportionality essentially involves answering the following three questions about selecting and obtaining evidence. The first question is, to what extent can a particular element of an evidentiary exercise be effective? That is, to what extent does it contribute to the discovery, identification, and or examination of evidence and to the resolution of the relevant issue in terms of constructing the evidential basis for the decision and the appropriate criminal response? Second question, second issue, is the measure proportionate? For instance, do the expected result justify the burdensome nature of the related interference with the human rights and freedoms? For example, the right to privacy. And thirdly, are there any alternative evidentiary actions that would be equally effective, but less, I don't know if I would be understand correctly, cumbersome. Yes. The principle of proportionality in obtaining evidence requires that it be shown that any act interfering with the rights or freedoms of the individuals is necessary under the given circumstances. And conclusion. As one of the famous lawyers, evidentiary lawyers, Miriam Damashka, suggests that the adversarial process is not essential, but the ideological underpinnings of the adversarial process derived from the Lockean liberal values of distrust of the state and freedoms from constraint may make these features and matter of a choice. Thus, as I have read in Jackson's and Dorogan monograph, The Judicial Role in Criminal Proceedings, published by Hart, they suggest that although the arbitrators in an adversarial trial may be lay or professional judges, provided they are impartial and independent of the parties, a jury of amateur judges, independent of the parties, may enhance the image of criminal trial as a contest because the jury is truly an external arbiter and cannot be colored by any taint of bias in favor of one side or another. In contrast to the adversarial procedure, the ideology of a non-adversarial procedure is one of collectivist values and so-called paternalism. Proceedings are conducted through an official investigation in which the judge, not the parties, is the main player in drawing out the evidence in the case. So, as I said, the verification of evidence is a mechanism which, by differentiating the individual partial evidentiary aims of particular tool, has in principle the task of equipping the trial organs, authorities with the limits of free assessment, with competence serving the directive principle of material truth. The effect of guarantee-orientated verification of evidence is due to consider whether there are any conditions that create possibility of using a given measure, conducting and introducing evidence and making findings. When assessing evidence, the trial authorities having the freedom of internal conviction and drawing conclusion, processing the freedom of internal conviction from it, and thus the freedom from any schematic in the respect should nevertheless take into account the elements which strengthen the legitimacy, purposefulness of carrying out a specific action, the proportionality, correctness standard of such evidence and its value, including the relevance, of course, the conviction out of the court on the reliability of some testimonies and unreliability of others, obviously remaining under the protection of procedural law, among others, when is preceded by disclosure during the main hearing, resulting from the implementation of the principle of material truth, is the result of consideration of all circumstances in accordance with the principle of audiatur et altera pars, and exhaustively and logically taking into account the knowledge and life experience justified leading to the judge conviction, which should be reflected in the justification of the verdict, which would allow, on the one hand, the balance of rationale between the implementation of the principle of material truth and the principle of free assessment or free appraisal of evidence, and on the other hand, to strengthen the to release the guarantees function not only of the principle of the free assessment of evidence, but also the entire variety stages of evidence process in criminal case. And the last thing, verification of evidence is a complex and multifaceted guarantee mechanism aimed at eliminating evidentiary act performed by an unauthorized person or authorized body without legal basis, or by person or body acting ultra vires by declaring it inadmissible or even invalid. Verification of evidence is thus a legal and evidentiary safeguard. The verification of evidence should prohibit the use of evidence that is materially flawed or that touches a particularly sensitive sphere protected by human dignity. The latter case justifies the prohibition of evidence that violates the Convention, human rights and freedoms. The mechanism prohibits the falsification of evidence, certain methods of taking evidence, to use of torture and coercion of self-incrimination. Any violation of the standards of Evidentiary Act in a democratic state under the rule of law must result in the evidence obtained in this way being declared inadmissible, since the use would be tantamount to a denial of the fundamental guarantees and social legal values on which the criminal trial is based. And the last word, the verification, regardless of whether the process is adversarial or inquisitorial in the nature, is therefore a guarantee mechanism that allows for a broad analysis of the gathering, obtaining, conducting, evaluating, and managing of evidence and evidence gathering activities. It is based on the rules of evidence, in particular on the admissibility of evidence, and as I said multiple times, standard, quality, relevance, proportionality of evidence gathering facts. Thank you very much. I hope you noticed something interesting, and let me just thank you once again, and I hope you have some remarks, questions. Thank you.